On? Okay, that's on. All right, hey everybody. Good afternoon. My name is Don Nguyen. I am a Florida bar licensed attorney, specially appointed by the City of Titusville to serve as the magistrate for today's code enforcement hearings. These public hearings are quasi-judicial in nature. While formal rules of evidence do not apply, fundamental due process will be observed. Everyone with the case today will have the opportunity to present testimony. You may also present evidence or call witnesses to testify on your behalf. Please note that there is no public comment portion during code enforcement hearings. To speak on a specific case, you must either be the respondent or a witness called to testify. Everything said today will be recorded. All testimony will be given under oath. When you are sworn in, please state your name and provide your current mailing address so we have an updated record for sending any orders. The city will present its case first. Information will be displayed on the screens, and documents may be provided by the city as evidence. The city's PowerPoint presentation will also be entered into evidence unless there are any objections. After all evidence and testimony have been presented, I will make a ruling. My ruling will be reduced to writing and mailed to you. At this time, I'll swear in all witnesses. If you intend to testify for your case, please stand and raise your right hand. Sorry, sir. All right. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Thank you all. You may all be seated. Let's go ahead and go to the approval of last month's minutes. I have them here in front of me. I've reviewed them. I discussed it with my partner, Mr. Fong, who did. So I'll go ahead and motion to approve those minutes. And we'll go ahead and move to the first item on the agenda, which is the lien reduction hearings. So the first case is 24-93. The owner is DWB Developers, Inc.
So the original magistrate case number was 24-93. This is the lien reduction request hearing. Our applicant and current owner is DWB Development, Inc. Our mailing address, 846 North Cocoa Boulevard, Suite C, Cocoa, Florida. And that's for our owner. The violation address is tax ID 221-8100 on Louisiana Street. And the original violation was subsection 302.4 for overgrowth. So the case was originally heard September 9, 2024. The respondent did not attend the meeting. The respondents were given until October 12, 2024 to correct the violations. And if compliance was not achieved, a fine in the amount of $100 per day commencing October 13, 2024, and continuing daily until the violations were corrected. Administrative costs in the amount of $198.90. The Massey hearing was rescheduled and held on December 9th, 2024. Again, the respondent did not attend the meeting. The city, I represented testimony that they had failed to correct the violation on or before the October 12, 2024 deadline, and that at the time of the December 9th hearing that the violation was still occurring, and the fine amount of $100 per day was started October 13, 2024, and the administrative costs were imposed. So on March 25th, 2025, the property achieves compliance, verified by myself, and the total accrued daily fine was $16,400, with the administrative cost being $198.97. On May 19, 2025, the Code Enforcement Department received the Delpret is here to speak on behalf of the owners. So this is the property appraiser information for the property on Louisiana. It is a vacant lot. on Louisiana Street. The rest of the lots in the subdivision have been built on. This was the photo from the Massey hearing taking December 4th. From the Massey hearing presentation again. And this was from July 1st when I went out to get pictures for today's hearing. The property since March has been maintained, and the owner has stayed in contact with code enforcement. So as of December 9, 2024, the property is found to be in violation and a fine was imposed. On March 25th, 2025, compliance was achieved and an application for the lien reduction was received on May 19th of this year. The respondent is requesting a reduction in the amount of $16,000. And Mr. Delpret is here.
How are you, sir?
Thank you. The property was purchased on October 20th of 2023. And we moved our office on January 1st of 2024. Subsequently, all the notices to get the grass cut wasn't delivered to us. And actually, just today, I found out from your code enforcement agent that the property that our office address, our mailing address, is still not changed in the Brevard County tax records. So I didn't get the notices, and then somehow they contacted the agent, who happens to be a partner. We weren't in compliance, and that's when we started taking care of it, in a much better way. So since I've known that the neighbors and the community has been upset over the overgrowth, I've been trying to be as good of a neighbor as I possibly can. We even have the concrete edged, and I have a contract with a landscaping service that goes out there every other week, and I had a retardant put down on the area so it wouldn't grow that fast. And that's basically what I say. $16,000 seems it would devastate us. So I don't know what else to say.
It's Mr. Delpret?
Yes.
Sorry, if I'm pronouncing that correctly. What is your mailing address now?
Well, I would appreciate that you send it to my home mailing address. This way,
Have you given that to Officer May?
no, I'll give it
Okay.
to her now.
Can you go ahead and provide it for the
But
record now?
Yeah, you'll get immediate response if you send it to my home mailing. You
Which
want
is?
it now?
Yes.
Yeah, 4801 Durango, that's Durango Place. That's West Melbourne, 32904. And I assure you, any correspondence there will be immediately addressed. I think the code enforcement agency agent could attest that I've been very compliant in trying to,
Right.
be as cooperative as possible.
You said you did find out eventually because of the, was it the registered agent that let you know?
Registered agent let me know.
And what is his name?
Travius Williams.
Is he the owner of this Satar Corporation?
Right, that's correct.
And you said they are also owners of DWB?
Well, he's a partial owner of DWB. The whole idea is we're currently trying to buy, they're contractors and real estate agent, and we have a little corporation where we try to buy some land and try to eventually build on it. This piece of land happens to be very nice, and I may consider it for a personal residence. So I really don't want to get the people there upset. I don't want to, them to be mad at me before I even move there.
Did you have something you wanted to add, officer?
Yes, sir. I just wanted to ensure that proper notice and mailings were done by the code enforcement department at all times.
Right.
And I just want that to be.
Where,
reiterated on the record.
so in the documents that you provided me, Officer May, I see you have 2 addresses notated there. Are those are those the mailing addresses notated on the property appraiser's website, and I would imagine on Sunbiz as well for the corporation?
Correct. So the COCO address is the listed owner's information from Brevard County Property Appraiser.
Yeah, I see that.
And the 6905 North Wickham, that's the address I found listed for Solterre Corporation.
Yeah, and that's what is listed on Sunbiz as the office mailing address and the registered agent address for DWB on Sunbiz with your last annual report filed in April of 2024, which would have been after you guys moved. So, you updated with the state that the 6905 North Wickham is your address. Now, that being said, I do believe everything you've said here today. I do believe had you personally known ahead of time, you would have taken action to remedy it quicker than it was done. The issue is you alone are not DWB. DWB has multiple people apparently, and apparently the notice was properly sent to those addresses that they had on record. And so that's unfortunate what you're saying.
But
First,
the address on Wickham, when was that?
according to the annual report on Sunbiz, which is, the Secretary of State for the state of Florida, it was last updated in April of 2024, and that was the addresses given for DWB. So, as far as code enforcement can tell, that's the correct mailing address, right? And according to you, you're, Solterre did find out.
I believe the addresses were going, the letters were going to COCO.
I see in this document you gave me, were notices also being sent to that 6905 Wickham?
Yes.
Yeah.
Trying to find a copy of the notice of violation for you.
There's no structure, right? It's completely, it was just a vacant lot of land, correct?
That's correct.
Yes.
Okay.
So this is how, oops, that is not the right page. Oh. I don't have a copy of the original notice of violation. But I have the certified letter that was returned.
Mr. Del Prat, do you know how your partner came to find out about these notices? And when did he inform you?
I believe I was informed in the early part of this year. I'm not sure what month. See, the first 2 letters here, even in December of, one is December of 24, and the other one is, both of them in December of 24. They're sent to the wrong address, and then they were returned.
Wrong address as in what address?
864 Cocoa Boulevard.
864 or 846?
846,
Okay,
I'm sorry.
All right. Oh, good. Well, one is the wrong address, one is an old address, right? So,
Apologize, I thought I had put a copy
okay,
in.
that's fine.
This is how the notice,
Right, so,
and that's how it was mailed out.
Yeah, the issue is the city can only send the mail to addresses that are available on record. And if you don't have it updated on the tax records or property appraiser or on the Secretary of State's website, there's not much more information that the state, or I'm sorry, the city is able to go with. So, you know,
Excuse me, unfortunately, with other properties.
let me just continue. So I'm saying this to say that I'm not so much moved by the, you know, we didn't receive proper notice via mail argument. I'd be more concerned because there's other factors we can consider when it comes to like reducing a lien. So one of them is the gravity of the violation, and obviously I know, you know, there's no structure involved. You're not talking about an immediate danger. One of the other ones that we can take into account is because you solely individually are not the owner, it's a corporation. So I'm trying to separate the fact that I feel like the corporation knew or should have known earlier. I'm talking about you because you're here today. So how soon after you personally found out did you actually take any action?
I took care of it immediately. I mean, I believe when I was first contacted, your last name is Wright? Yeah, by Mrs. Wright, I took care of it the next day. We got the property cleaned up. And then, since then, I've gotten a lawn company to cut it every other week, and we put down a retardant to slow the growth down. So, you know, and I try to keep it as nice, you know, as if it was my own house, you know. Curb is edged, you know, the sidewalk is edged and everything. People in the neighborhood would be fine walking past it, you know.
Right. Officer Wright, is that accurate as far as you? Has he been responsive and, you know, kept in contact with you as he's been doing these more corrective actions and maintained?
In March, he's been on it. It's been maintained. I haven't had it come into violation since that point.
I think the strongest determining factor for me in making a decision, though, is the amount of the enforcement lien compared to the market value of the property. I don't think I saw any information as regard the market value, but I can't imagine. Well, I would imagine 16,000 is a significant proportion to the value of it.
I paid $34,000 for the property.
What is it?
I paid $34,000 for the property.
Do we have the?
Yeah.
What is the value here on the? Actually, I can bring that.
Market value is listed as 10,360,
Okay.
10,330.
The appraised value, you mean? Oh, the appraised market value, I see. Okay. Do you have any other financial hardships or any other factors you'd like me to consider in making a decision?
And $16,000, I don't know. I just have to probably give up the piece of land, but you know, I couldn't possibly afford that.
No, I understand.
You know, I can, you know, a fine would be, you know, a reasonable fine. I could understand that, you know, but when we're talking in thousands and stuff like that.
I mean, I do think that there is, I do think a fine is appropriate. I'm not going to be reducing it by 16,000. I will be reducing it. I'm trying to articulate and hopefully reach a number that I feel is reasonable. I mean, the fact of the matter is I do think that notice was properly sent. And it sounds like you probably need to talk to your partners about the mailing addresses and the lines of communication when like significant or, you know, serious legal notices are coming through. So there's not a lag time. If you're the one that's going to be handling these things, you know, they need to know that to the extent that those come in, they need to give it to you immediately,
Yeah,
right?
that's why I offered you my.
Of course, but you will have to also make sure that those are properly reflected in all the other records as well, right?
Yeah.
So I do think a fine is appropriate. I'm just trying to think, you know, how much of a reduction I feel is fair. I don't know if the city has anything else, or otherwise I'm just going to pick a number.
No, sir.
All right. Okay. So I reviewed the lien reduction application and the city code provision that is applicable, and I've considered documentary evidence, including photos and sworn testimony relating to this matter from city staff and the respondent. In making my ruling, I am considering the factors that are set forth in City Code 31-71. Specifically, I am paying most attention to the gravity of the violation, being that there is no immediate harm, no structure, anything falling apart, anything quite like that, no immediate danger to anyone. But most importantly, the amount of the enforcement lien compared to the market value of the property. I'm less influenced by the notice aspect because I think due notice was provided. However, I will recommend that the city council reduce this lien to $3,000 based upon the factors outlined above. In addition to the lien amount, the lien will include the costs incurred by the city will be added to that amount, which is $198.97. Altogether, it would be $3,198.97. It is so ordered. You will receive a written order from today's hearing, which will just be a recommendation to the city council. You'll have notice and opportunity to attend the city council meeting where the recommendation will be considered. Okay?
All right, thank you.
Thank you.
Excuse me, sir. Will those be mailed record or?
I think we have to continue sending it to the Sunbiz address. I mean, if he's been told.
We would provide the copy, but I think it's imperative that we continue on with proper service with the other.
Of course, yeah. Yeah, so to the extent that the clerk needs to add this 4801 Durango, please ensure that it is added for the mailing list for him. Okay. We'll move on to the next item on the agenda. I believe that is 25 dash, I'm sorry, we're done with the lien reduction hearings. So we'll move on to the Massey hearings, the first of which is 25-27. And Officer Flanagan, I'll let you take it away.
Oh, yes, sir. For this case, I have a notice of hearing for you.
Thank you, officer. Go ahead.
Okay, good. Okay. Again, the address is 1435 Brook Drive, and the only violation at the time that we're coming back to is the roof and drainage. Notice of hearing and everything was posted at City Hall on June 30th and certified mail on June 11th and signed for on.
They signed.
That should be, no, it was signed for, but I apologize. It's on the affidavit.
They traveled through time.
This case was originally heard on March 10th. The respondent was found in violation and given until noon on April 11th, 2025. At the April 14th, 2025 Massey hearing, the respondent was here, and if you remember correctly, sir, this was the issue with the mailing.
Sort of remember.
Sent it to
The name is familiar, but I don't remember.
Yeah, the mailings apparently there was an issue with the mailings. They weren't going to the proper place, and there was a vacant house at the time, and he didn't have the proper address. And at the time, we agreed to extend the violation for 60 days. Mm-hmm. And if he didn't comply and have the roof finalized by June, I believe it was June 14th,
right.
The fines would be retro back to April 11th.
Okay.
As of today, the roof is still not in compliance. He has put some shingles on, but it hasn't been done and complete as of yet. Here are the original pictures back in July 29 that we presented, and that was back in February. That was April, just before the meeting, if you remember correctly. And here's June of 25. You can see he did start the roof a couple of weeks ago, and as I went by today to check for compliance or not, it's still not complete, and the permit hasn't been signed off and approved. Should be noted that the permit was not issued until the day that you were given him to comply, and that was in June. And again, the property hasn't been put in compliance as of today. It's still in violation. So I guess the recommendation would be to, have the respondent pay the amount retro back to April 11, 2025 for the $100 today and continue until he corrects the violation. and he is not here today.
We resolved all the mailing issues, right? Oh, you said he signed for this one.
He signed for it. We sent it to the Barna address like he requested, and he made contact saying that he was going to be here, and have no idea why he's not.
Have you had contact with him otherwise during the
No.
scheduling inspections, anything?
No.
What date did you say he filed for the permit? I
It
applied
was
for
on
the permit.
June, I apologize, I thought it was, should be in there, it was like June 4th.
Go back one slide.
No,
There you go, roof permit.
no, that's not. It was the Friday before the
Gotcha.
last hearing.
And we're sure he's not out in the hallway or
No,
anything?
No, he's not
Okay.
out there.
All right, well, makes my job kind of easy. All right, I find based on the evidence and testimony presented that notice was properly provided to the respondent and the respondent did not appear. The evidence demonstrates that the property located at 1435 Brook Drive in Titusville, Florida, 32780 remains in violation. Let me see, let me get the exact violations that are going on. It's just a roof permit, right?
Yes.
Yeah. Specifically, the respondent is still in violation of City Code 6-109, 2018 IMPC, Section 304.7. No repairs or corrections have been made pursuant to the order entered previously, and the property is not in compliance as of today. Therefore, I find that the city has established a continuing violation of the aforesaid provisions. Accordingly, a fine of $100 per day is imposed commencing on is it April 11th or April 12th? April. The order that I entered says retroactive to April 12th. For your recommendation, says April 11th. Let me see. They were supposed to have compliance originally by April 11th, but my order from the April hearing said will be retroactive to April 12th.
Correct.
All right, sorry. So a fine of $100 per day is imposed commencing April 12th, 2025, and continuing daily until the violations are corrected. Additionally, the cost of $251.80 has not been paid. A certified copy of this order will be recorded in the public records constituting a lien on the subject property. The respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm.
Excuse,
Yes, sir.
the costs have been paid.
Oh, they have been paid.
Yes, sir.
All right, let me fix that. So the costs have been paid and will not be added to the subject lien. Sorry about that.
Okay.
Oh, okay, I see that. Have been paid. All right. Thanks for catching that. Okay, the next item on the agenda is also a Massey hearing. This one is for Robert Kirk, 25-33. I'm sorry, Robert Kirk and Crystal Cook.
So I have two items to submit. The first is the affidavit for the notice of hearing for today's Massey hearing. And the second is a copy of the cost of recovery. I think that's already in the file.
Thank you.
Do you want to just have a seat?
Give me 1 second.
So once again, this is the Massey hearing, the second Massey hearing on case 25-33. Respondents Robert C. Kirk and Crystal Kirk Cook. Mr. Cook is here today. Our violation address and mailing address are the same, 925 Cleveland Street in Titusville, Florida. Hearing is for code violation subsection 304.14, and that's for windows. So the notice of today's hearing was posted at City Hall and on the property on July 1st, 2025. Certified and first-class mail was sent June 11th, and the certified letter was signed for June 14th of this year. So again, this case was originally heard March 10th, 2025. The respondent was present and provided testimony. The respondent was found to be in violation of the stated codes, and specifically to correct section 304.14 on or before noon of July 11th, 2025, or a fine in the amount of $100 per day per violation commencing July 12th would be issued. And the administrative costs in the amount of $216.58 were imposed. So the original Massey hearing was heard June 9th. The respondent did not attend. Reinspection took place July 11th around 12:45 p.m. The property still remained in violation. There had been no permits pulled through the building department for the replacement of windows, and the windows on the house were found to be damaged and or boarded. I did speak to Mr. Kirk on the phone that same afternoon and got permission to take pictures on the property. And we did discuss today's hearing and the status of the repairs. So these are the photos taken or from the initial hearing presentation. We've got, so these are windows along the front of the house. These are along the south side of the house. This is on the front again. And the backyard. So these are my photos taken July 11th. So we've got the two windows on the south side are still boarded. Two more bedroom windows still remain boarded and damaged. Two more windows on the front of the house, on the living room, and then are damaged. They're broke. They're not boarded, but the glazing is broken. And then on the back of the house, we do have a damaged window. So, conclusion of fact for 304.14, multiple windows still remain inoperable or damaged, and no work has started to correct that violation.
We're just here today on the 304.14, not for the
Correct.
jumping debris. All right,
Correct. 1223 was found to be in violation at last month's hearing, and the $100 a day was imposed at that time.
Okay. All right, Mr. Kirk, how are you? You may stay seated. I think we spoke.
Look,
Okay.
like she said, that first notice was March 25th. To all fairness, okay, my aunt was Jessie Kirk. She was murdered March 4th. My brain was scrambled, okay? Not trying to make excuses, okay, and my situation, I've been very ill, very, very ill. I now also told you when I was here before that I'll either have them fixed and be in the process of doing that, or I will bring a buyer with me that's going to put a contract together. Well, me and him been going back and forth for the last 60 days. And we finally came to a conclusion last week because I dropped my price another $10,000 on the house. Because I'm going to sell and I'm going to Alabama where my grandkids are. I was born in Titusville in 1961. And after what's happened to my aunt, I don't even want to be here. I'm just sick to my stomach, you know, and the way everything's, but you know, I didn't get enough time. When I was in here talking to you before, I should have got more time. And I was justified that. I really was. But, you know, and I'm new at this. I don't, you know, I've never been in any situation like this before, but Mr. Fry can tell you that we have come to an agreement, and the house, contract is being drawn up, and we think we'll have me on the way to Alabama in 30 to 40 days. And he's taking it the way it is. There's a couple renters in the house. Most of them are gone, but there's a couple renters in the house. He's gonna deal with that. That's all being taken care of. And like I explained to you before when I was here, I got in over my head. I have one section of my house, and that can be a horror show if you don't do it right. There is people who do it and are very successful at it. They get a good return on their investment, but I wasn't one of those. I did get a few good ones. I had one man for 9 years, and he was good, and ex-Marine Corps guy, and kept everything clean and nice. And just like last week when I called him up, I talked to her on the phone, standing that everything in the backyard was cleaned up, was nice. And then I had one of the guys, because I don't get around good, I have to get around with this cane and stuff or a wheelchair. And he brought pictures back to me and showed me. And that's when I made up my mind. That's when I got him on the phone. I said, hey, let's make it happen. I said, I've got to go Monday back in front of the Magistrate, and I'm done with it. I'm over. And they're all upset with me right now because they don't know where they're going to go, but I don't really give a damn. I said, you should have done more and stuff. So, and the only sad part about it is a couple of them are good people, and they do pay their bills and do what they're supposed to, but I can't worry about that. But what I'm asking you, if you'd give us extended 60 days, and he because as soon as he takes it, they're gutting it. They're rolling in there with a container, and that's what they do. And they have to work fast because they use borrowed money, and they have to get them done and get them flipped. That's what they are. And he's got a track record of doing several throughout the county. And it's him and his sister. His sister, Ashley, she would have been here today, but she was giving birth to a new baby. And the sister works for Adams Homes also, and they have this little side business of flipping homes. But that's all I'm asking. Just give me one more extension. She's been real great to work with. She's the one that brought the officer to my house when she saw what I was going through and helped me get some of the mess cleaned up. 3 of them that was in my house ended up in the Wayne Ivy Lodge, and that's where they're at right now. But, it's just, like I said, I learned a lot about that time. If I was to ever do anything like that again, I would give it to a professional real estate company that handles all that type of stuff. And I wouldn't do it myself, but that's basically all I have to say,
Officer Wright, do the windows or anything appear in any better condition than they were 90 days ago when we met here for this?
No, sir, they're in the same condition.
Is this the type of work that requires a permit, or?
If they're replacing the glazing.
That's right, yeah.
It would not require a permit, but if you're replacing multiple windows on a house, then yes, the permit is required.
Yeah, and he's gonna gut it. He'll tell you, he's gonna.
I understand all that, and I hear what you're saying, and the issue is, this sort of Massey hearing, all I'm here to do is determine whether or not the violation still exists. We're not here to relitigate whether you needed more time as of, of this past April. We gave you 90 days at that time, and, which was an extended period beyond what was already granted for the other violations. And so I can't go back now and say, we're going to give you more time, because this is simply a yes or no question. Does the violation, which we gave you 90 days to fix, is it still in violation? And it appears that it's still in the same condition as it was before.
Well,
So.
listen, I was on the phone to Clay, and I was gonna, and I've I even told her, Clay at Coastal Glass and Window, okay? And if you call his phone number right now, accepting any work for this month and next month because they're overbooked, okay? So, and so I went to Home Depot and Lowe's, and I could get military discount there. And the windows that are in my house are standard. It doesn't take no special order or nothing, but, you know, sometimes they have them, sometimes they don't. Sometimes you gotta wait on a truck. And so, you know, and then that's when me and him got more serious in our negotiating. And then I really wasn't sure if I was gonna have the guys that I needed to help put them in. I was kind of wishy-washy there. And so, you know, that's where we're at. But if I could just get, you know, I mean, me and him were just talking, you know, we think he'll have me done in 30 to 40 days. If I can get that, y'all see me no more. I'll be loaded.
But it's not about you, Mr. Kirk. It's nothing personal against you.
Yeah.
Even if you were to, for instance, sell it and the closing occur within 30, 40 days, that doesn't fix the violation in and of itself. Then we have a situation where, whether it be this gentleman or some other buyer coming saying, oh, we bought it in this condition, we need 60 days to fix it, right? And so I understand what you're saying, but again, my charge here today is just whether or not it's still in violation. That's all there is.
Okay, let me ask you this, would you be okay, me and him were just talking about it, if the 6 windows that are bad, okay? If we went ahead and got started on those, pulled the permit, got started on those, and started replacing those till we got the closing done. I mean, you know, to satisfy y'all, you know. She'll tell you, I call her when the grass gets mowed. I call her, you know, every time we do something positive, I call her and I let her know. I'm not a person that, you know, that's just out to do something wrong. Now, do I have a couple people in my house that, you know, does stuff like, you know, stuff that was piled on the porch last week, and the porch was perfectly clean, and it was pressure washed, and the front of the house was getting ready to be painted, you know, and they went and did that to me, you know. When I got up and I saw it, I just, oh. And then I didn't know that there was stuff still in the backyard, because we've hauled a bunch of stuff out of the backyard. And
But again, the issue that you're putting us in is now you're saying, wait till after I sell, and then we have to hold this exact same hearing with the new owner. And so that's,
but if we're
whereas if we,
get to that date, do you want us to go ahead and get started since the windows?
well, I would recommend you get started immediately, but
It seems like the windows is, you know, the deal breaker here. So if you
But-
want us to get started on them windows, we will.
The short answer is yes. If the windows are repaired, you call me, I come out and do an inspection, verify that it's in compliance. We put that violation in compliance on that date.
Okay? Are you okay with that?
Officer. Yeah.
Yeah. Okay.
All right. Well,
Be noted with a potential new buyer here to know that there are already $3,700 in fine accrued from the
Yeah.
original hearing, as well as $216.58 in
Yeah.
cost to the city.
understood.
And this will be time to him to know, come and know now, as opposed to coming in for
Right.
a lien
Well, we-
reduction hearing saying, I didn't know.
Right, and I think that's a good point. So if you or, you know, a different buyer comes and, you know, you get the title work, you will see that there is a lien already on the property for other code enforcement violations. Now, for this one, it would start accruing commencing on July 12th. But to the extent you can get it done immediately, that might just be minimal, right? So
What is that other one that you say that's against it right now? What is that first one?
it's for
That's the
junk and
trash, junk, and debris.
Okay. and how
It's
much
still
is it?
ongoing.
How much is it?
I,
Oh, is it per day or is
It was $100 per day,
$100 per day?
and that started on June the 7th. And you're currently up to $3,700 or $37, or 37 days currently.
So, okay, thank you all. I find based on the evidence and testimony presented that notice was properly provided to the respondent, and the respondent did appear The evidence demonstrates that the property located at 925 Cleveland Street, Titusville, Florida 32780 remains in violation. Specifically, the windows or 304.14 have not been fixed, and the property is not in compliance with the previous order dated April 14th, 2025. Therefore, I find that the city has established a continuing violation of the aforesaid section 304.14. Accordingly, a fine of $100 per day is imposed commencing on July 12th, 2025, continuing daily until the violations are corrected. Additionally, the cost of, sorry. You gave it to me. What are the costs?
216.58.
$216.58 has not been paid. So a certified copy of this order will be recorded in the public records constituting a lien on the subject property. The respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. So Mr. Kirk, as soon as you get that done, that clock stops ticking and that lien is less.
Reason I wasn't here in June, and she knows this, and I asked her, did I have to come, because she came in the house, came back to my bedroom and saw how sick I was, okay? Otherwise, I would have been here, okay? I don't play that game. If I'm in trouble and I need to face it, I go to it. I've been here since 1961. My family has a very good reputation, okay? And you know, so I do not play that game. And so I think you need to reconsider, because she did not tell me that I was going to have a fine recurring every day. Now he's telling me $3,700 something. That's not right. That's totally not right. You know, like I said, I couldn't be here, and she knew and I asked her point blank. I said, look, you know, I said, you know.
Again, it should be noted that Mr. Kirk was present when you made that initial ruling.
Yeah.
And it was beholden of him to return or have some representative in his behalf.
And Mr. Kirk, that.
As we did postpone it additional 30 days
Right.
as it was.
Right.
But you also said, sir, if you go back and check the notes, okay, you need additional time, because, we even said that at the time.
But right now, we're talking about the windows and
Yes.
everything like that. And what we're talking about is, and something that's, and again, I've already ruled. But the issue is that no efforts have been made.
Huh?
No efforts have been made. It's in the same condition as it was 3 months ago. No permits have been pulled. No evidence to show that you've made any such efforts, so.
Today, we're gonna check on the permits. I've asked you,
Yeah.
you told me where it's at.
And again,
You know, 'cause I've never had to do this before. But, okay. Well, we'll get busy. We'll get
All right.
busy working.
Thank you, sir.
Getting it done as quick as we can.
All right.
Thank you, sir.
All right. Move on. I think that concludes the Massey hearings. Oh, it's just a simple matter. Is it still in violation or not? Anyway. Now we're on to, there's no continued hearing, so now we're on the initial hearings portion. The first matter is 25-68, and this is for the owner, Ratliff. Here you go.
And I have 3 items for you, sir. The notice of violation affidavit, notice of hearing affidavit, and the cost recovery for $216.58.
Thank you, officer.
All right. Again, this is 160 Park Lane for junk and debris. Oops. There we go. The initial inspection was on March 19, 2025. Violation was posted on the property. It was given till April 3rd, 2025, the correct violation. It was mailed to as well on March 20th. Certified in first class, and it was posted on the property in City Hall on June 30th. On March 19, 2025, observed several debris items in the front yard after receiving a complaint. Observed furniture, miscellaneous trash, and other items. I posted a notice of violation at that time. Inspection found the property remains in violation for the junk and debris. There has been no contact with the owner. There's been junk items coming and going. This is the initial violation back in March with the debris in the driveway. And this was a same in the front yard, different debris, furniture, and items in the front yard. This was the follow-up back June 30th. The washer in the driveway. The vehicle is also inoperative. There's no tag on it. When I walked up to post it, I could see it from the back driveway. There's another picture of the front yard. There's like a microwave and different furniture items in the front yard. And as of today, when I went by, there's still debris and items in the front yard and that junk vehicle. The conclusion of the fact, the property has numerous items of junk and debris in the front yard in violation of city code. The recommended is to remove all the junk and debris from the items and the vehicle as well, store inside out of view, or remove it from the property. Order the respondent be assessed the administrative cost of $216.58. If the respondent does not comply by August 8th, it is requested that a fine of $100 per day be imposed each day until the violation is corrected, and to contact me for reinspection when it is done. And the respondent is not here today.
And no contact with the respondent, you said?
No contact at all, no.
All right. I have accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent Evelyn Louise Ratliff is the owner of the property with the address 160 Park Lane, Titusville, Florida, 32780. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on evidence presented, I find that violations of Section 12.23 of the City Code, which is regarding junk and debris, exists upon the property, and respondents were given a reasonable amount of time to correct the violations, but have either failed or refused to do so. The corrective actions for these violations is to remove all the junk and debris items from the property or store inside out of view. I find that the city has incurred costs in the amount of $216.58. Such amounts shall be included with this order. Respondent shall be given until August 8th, 2025 to correct the violations. Respondent shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by August 8th, 2025, a fine will be entered in the amount of $100 per day until the violation comes into compliance. Further and future violations of the same sections shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. All right. Move on now to, give me a second. Looking at 25-70. That's BAF Asset 6 LLC.
Again, I have a hearing notice affidavit, violation affidavit, and the cost recovery of the same $216.58.
246.58. Okay, 216. All right. Yeah, on this recommendation action. 216.58. All right.
Get my discount.
Okay.
Ready Avenue, this is for a parking violation. Initial inspection was in February 12th, 2025, and it was given until March 27th to comply. Notice of violation was mailed certified in first class, and notice of the hearing was also posted certified and posted at City Hall and on the property. Received a complaint referring to several vehicles parked on the front yard. I observed 4 vehicles at the time parked on the front yard in violation of city code. After doing the posting and doing the mailings, I received emails from the property management company expressing that they had corrected the violation, but I would go back and found that it was still in violation. I received another email last week stating that it was corrected, but I informed them I'd still be coming to the hearing today. This is just a quick description of the parking violation is no off-street parking in front yard, rear yard, side yards, unless it's driveway or designated parking space or area. These are the vehicles as of the initial violation parked all over the front yard. Same thing back in May 27th. This was in February. Several vehicles on the front yard. This was of June 23rd. This is the one I sent back to the property management company, explained to them that it had not been corrected. This is tenant occupied. She was under the impression that it was. As of last week, I explained to them that it was. I'm sorry, since last week, I have not seen any violations on the property, but I explained to them that I would be still coming to the magistrate hearing, like I said. The conclusion of the fact that there were vehicles parked on the front yard against city code, and for the recommendation, the vehicles need to stop parking on the grass and only park in the allowed areas. They'd be ordered a respondent of the 216. That was I don't know why that is, but does not comply by August 8th, 2025, and a $100 day each day for the violation if it continues. I think this is going to be more of a finding of fact. I believe the violation has been corrected, but I would go with your recommendation if it's okay for a finding of fact that if it does occur again, that they would be notified and a fine would start from then.
The city would recommend just a finding of fact in this matter.
Is that usually how you do it for these sort of more like, I guess you would say like transient violations that can be remedied, but they can come back? Is that usually how you?
Yes, and then that would expedite our next time with that property in violation. We can come straight to the hearing
Okay.
as it being found as a repeat violation at that time.
But just out of curiosity, so how would that work for Officer Flanagan? You would just go out there, or will you just wait to hear reports, hey, there's parking out there again?
It's close to a main street, so I do check it at least once or twice a week, or if I do
Okay.
get a complaint again. And then if they do park on the street, the violation would start on the day they get notified.
And at that point, we would set it for a massey hearing? Is that what we would do?
The fines, yeah, basically.
Actually, we would bring it back as a repeat violation.
Oh, I see, okay. Okay, I just want to make sure I don't think I've done just a simple finding of fact before, so let me make sure I use the correct language. I'm just a robot, I can just read the script. All right. BAF's not here, no, the registered agent, no one on their behalf is here?
Nobody's here.
Okay. All right, I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent BAF Asset 6 LLC is the owner of the property of the address 2765 Liberty Avenue, Titusville, Florida 32780. I find that all Florida statute and city code and notice was met for this hearing. Based on the evidence presented, I find that the property was in violation of section 20-58 of the city code regarding parking regulations. Specifically, vehicles were parked on the grass in front and on the side of the property. The corrective actions, well, it appears to be corrected as of the time of this hearing. To the extent that any future violations occur, we'll just how would you word that part in the order?
Actually, if you would, sir, that the violation was corrected as of this meeting, and from here forward, any future violations would constitute a repeat violation.
Got it.
And to be brought back in front of this hearing.
Got it. All right. So as of the date of this hearing, any future violations will be brought back before this special magistrate for a repeat violation hearing. Additionally, I find that the city has incurred costs in the amount of $216.58. Such amounts shall be included with the order. That's it, really, right? They have to pay the costs,
Yeah,
right?
yes.
Okay. Further and future violations, future hearing before this magistrate. Certified order may be recorded in the public records of Brevard County. It is so ordered. Sorry about that. Thanks for
Thank you.
hand-holding me through that.
Thank you, sir.
All right. Okay, we are at 25-71, George Raymond Donald, or Donald, Senior Trust.
Me to have them speak first? No. Okay, all right. So I have three items for submittal. The first is the notice of violation and affidavit. The second is the notice of hearing and affidavit. And the third is the cost recovery statement in the amount of $128.53.
Thank you.
So once again, this is the initial hearing for case 25-71. Our respondent is George Raymond Donald Jr. Trust. The violation address is 8251 Windover Way in Titusville, Florida. And our mailing address is 70. So there's 4 violations right now. It's section 6-109 of the International Property Maintenance Code, subsection 302.7 for accessory structures, 304.1 for general exterior, 301.3 is vacant structures and land, and 305.1 general interior maintenance. So the initial inspection was completed January 31st of 2025. A copy of the notice of violation was hand-delivered to apply was April 30th, 2025. Certified and first-class mail was sent to the respondent on January 31st, 2025, with the return receipt being signed on February 6, 2025. Today's hearing notice was mailed certified in first class on June 11, 2025, and the certified copy was signed for on June 14th of 2025. So a little bit of background, one of the buildings on this site, 2024. I reviewed building department files in January of this year, found no permits issued for the rehab of the structures, nor for removal of the damaged structures. I contacted the owner and scheduled an on-site meeting with George Donald Jr. We did meet at the property. We walked the property, all 3 buildings. There's 3 buildings and 2 fuel canopy islands. So all structures show signs of deterioration to the exterior walls and roofs. We've got signs of vagrant activity, people entering the property or going onto the property, graffiti, trash, things of that nature. Again, photos were taken for the file and the notice of violation sent. So I've stayed in contact with George Donald Jr. on this property, tracking the progress and what we can do with the property. Currently, all the violations remain active on the property. The Donalds do mow the property and try to pick up grass or trash on a regular basis. It's just an ongoing problem on the site. So just to give you an eagle view photo of the property, it is outlined there in blue. This was an old truck stop. So we have 3 buildings and 2 fuel canopies. So this is a picture of the 2 fuel canopies on the property. They continue to be vandalized and broken into. And then the canopy structures themselves, they're old metal canopies, signs of leaking and deterioration. So this is the first of 3 buildings. This is the old convenience store. This is the restaurant bar that was damaged by fire in April of 2024. And this is the third building. It was intended to be a strip center. So our conclusion of facts. So for the accessory structure, this is dealing with the fuel islands specifically. They continue to be damaged by vagrants and graffiti. Our general exterior maintenance for all three buildings, all the buildings have damage to roofs and exterior walls. The elements do enter into the interior of the building. For vacant structures and lands, the buildings are insufficiently secured against entry. The proper basis for by vagrants. And then for general interior maintenance, due to the damage of the roofs and walls of the buildings, the interior of each building are unsanitary. So we're requesting that the respondents be ordered to correct the violations on or before noon of September 5th, 2025. We are requesting that permits are pulled to either bring all the structures into to do maintenance on the buildings and bring them into a habitable condition, or to remove them from the property. And if the respondent does not comply by September 5th, 2025, we are asking for $100 per day per violation be imposed. And we are asking that administrative costs in the amount of $128.53 are imposed, and to contact code enforcement when the violations are corrected.
Thank you. And this is Mr. and Mrs. Donald? Or?
Hi.
All right.
I have a stack of papers for you.
I'm sorry, what is your name, ma'am?
I'm Julie Donnell. I am George Sr.'s daughter-in-law.
Are you the trustee of the trust, or?
He has just signed a POA.
Okay.
Which I'm going to hand you a copy of, or here, I'll just give you all of it. He's given me a POA to come and speak. His health is terrible. He's got COPD. He's lucky to make it to the bathroom. And he was really just not.
Are you gonna need any of this back?
No, those are all copies that I made for you.
Okay,
I
thank
made sure that.
Thank you, ma'am. Thank you, sir.
But as she has stated, yes, the buildings are old, tired, and an ugly mess. We understand that they need torn down. My father-in-law is a very proud, very private, and very stubborn man. He has just at the beginning of May, handling all the things that are going on, and has asked for that. So now I'm trying to play catch up and find out and do everything that I can to help him out. I'm just flipping through my papers. As far as the fire is concerned, kind of upset. It was a 5-alarm fire and nobody notified him that his building was on fire. He found out when he went to drive by to check on the property later. So as far as the code enforcement and getting everything removed, it was kind of misunderstood that if it was under a contract, that would halt the proceedings, but apparently that is not so. It is under contract. It is under contract as is, but I've learned a lot since he's asked me to help in the last month. So I've given you a copy of the contract and everything else. There's also an EPA issue that's been ongoing with it. The map that's in there in color is an old map. I've given them permission. We're in the process of scheduling a July 29th date for them to come out and do soil sample testing again, because apparently there was supposed to be a cleanup project out there starting back in the 90s. And I'm just trying to, again, play catch up and see where we are. So they have to get new soil samples, get a new report and a new plan. I want to make sure that whatever contamination they might find out there. Since getting the code stuff and asking to help, I have gotten at least 4 bids, And I have another one that should be sending me a bid on email as we speak. We have spoken with my father-in-law extensively, and we think we have him talked into getting some kind of financing to cover the demolition of the buildings, because they are a blight on Titusville. It's 100% agreed. It's just a matter of getting him to cooperate. We understand it. He's in very poor health. My husband is an only child, and push comes to shove, he is the sole trustee
So
slash.
you're the daughter-in-law trying to convince the stubborn father-in-law to do something?
Yes. Very much so, because he takes all his frustration out on his son, and he can't do that to me because I
And so your
talk
husband's
back.
like, I'm not dealing with it, you deal with it. Okay,
Yes.
I got you. How long has the family owned the property?
He has owned it probably since, what, the 80s?
Okay. So when it was operational as a truck stop, he was operating it
He
then?
built the truck stop. He bought the property vacant. He built it himself. That was his life. That was his castle. He was king. Having to close it down and let it go, and realizing that the end stage of COPD has taken away all of his, just losing any of your abilities to do things is so frustrating, and he takes it out on everybody. My husband has run interference and tried to save May from him. She's been a godsend and been very sweet. We've done everything we can to try to help keep everything as in compliant as possible. We do understand that the buildings need to come down. Like I said, I'm getting the quotes.
Sorry, I'm looking at the purchase contract, and I noticed you said it was as is, but it very much is not as is. They have a
Yeah.
120-day inspection period plus 2 additional extension options that can take this out 6 months from.
Yes, I understand
Yeah.
that this is a year-long thing because
Okay.
there's the due diligence portion, and then there's the permitting portion.
Are the buyers expecting you to raise the property before the closing? Is that what the expectation
I
is?
honestly don't know. Prior to the signing of the contract, I explained everything to him with the situation of what's going on with this property. My husband, my son, my father-in-law, my mother-in-law, we were all in on a group phone conversation. But the real estate agent will deny it all day long. My parents or my in-laws don't remember the conversation at all. My husband and my son remember me saying, before this contract is signed, what about all these things here? How are they going to be handled? And
Right.
my voice was not heard. Apparently, I needed to scream and jump from the
Yeah.
roof.
And the reason I ask that is because, and I think you've acknowledged the same as well, is like there's obviously, it's not just that it's an eyesore, it's also a liability,
It is.
right?
It's a
And that's a
huge
lot
liability.
that can happen between now and I guess the final cutoff date of all their inspection periods would be November, December timeframe. And so there's a lot that can happen between now and then, so.
Exactly.
I don't
And-
think-
And
yeah.
we're very close to having him talked into getting financing to have coordinate between the demolition and
financing,
the EPA folks, so that we don't cross-contaminate, potentially.
You guys deal with that
Contaminate
yourselves, but it
groundwater.
would be challenging for you to get financing with these
Well,
existing potential issues.
Some
Right,
other
right, right.
property that he owns.
Okay, I was gonna say that's,
Against that property,
Yeah,
I
okay.
wouldn't,
All right.
wouldn't even, a bank would laugh him right out the door.
So you've heard the city express what the violations are. There are certain ones that can be remedied quickly, like securing the vacant structures and stuff like that.
He has
Dave?
done everything he can to board up every single opening that there is, but where the building burned down, there's just unfortunately entryways that are impossible to board up. It's like whole walls are missing.
So usually, the city asks for, or will give you 30 days from these hearings to get the violations fixed. I guess given the gravity and the extent of these violations, the city has asked for 60 days for you guys from September 5th. So realistically, between
Would you be able?
I can try to board up a couple of them.
I can try to board up some of this real.
She just gets it.
I can try to board it up.
Yeah.
It's just so hard with the vagrants and stuff like that. It's, I can do what I can. I usually work with May, and I call her when, you know, whenever we get things.
The vagrants are relentless up there.
Yeah.
They tear things up daily. He was just reboarding things up where they tore other stuff up the other day. Because he drives by and checks on it almost daily for damage. Or new damage, or new places where people decided to use it as a dump instead of driving 2 miles down the road to the landfill.
Right. Is this a,
We would just love to have it cleaned up and gone as much as the city would.
this proposal for this demolition work, that was just to tear down all the buildings or just a couple
It
of them?
is to put everything back to nature. It's supposed, the proposals I'm collecting, the canopies torn down, I need all the concrete removed, and I need the tanks removed.
Did you accept this proposal or is this just out?
These
sitting
are,
out
none
there?
of these proposals have officially been
Okay,
accepted
okay,
yet.
got it. All right.
I've got, like I said, one more that's literally supposed to be working on the proposal
Oh,
as
I
we're
see the scope
speaking
on there.
today.
Okay, these are different ones. Okay.
But there are, I think, 4 in that pile and
Yeah.
one more coming. And then, like I said, I'm hoping to convince him to do like an equity loan on his house or something where he could write it off on taxes and pay to at least get the buildings demoed and
I almost
make
want.
forward
yeah.
progress on getting at least the liability part taken care of. And
It's unfortunate because I feel like if you guys were in charge, these decisions would be made, but you're not in charge.
Yeah.
And so I almost feel like being stricter on you and having an order be stricter on you will make it easier for you to say to him, hey, this is serious, you know?
Well, I've already told him that if he doesn't do what we tell him he needs to do at this given point, that the city of Titusville is like, they're gonna fine you $250 a day, and then they're gonna put liens on it, and they're not gonna wanna do that for very long. So it says, if you don't do something, they're gonna take your property, and then you won't have property to sell on that contract that you have. So basically, I keep telling him that he's gonna lose his property if he doesn't do something. It's a little bit of a fudge, but, you know,
Right.
if it sends the boot in the right place,
Yeah. I mean, I would just, you know, I imagine, and I don't want to put words in Officer Wright or, you know, Officer Tollison's mouths, but I would imagine if in 2 months' time, if you have everything boarded up to the best of your ability and, you know, either have some type of permits pulled for the demo work or something other, more concrete plan, more time would be afforded at that time, right? Because I can't imagine you'd be able to. And again, I'm just
Yeah, no,
saying,
I
can't
understand.
imagine
This is a big
if you were to
project.
contact any of these and say, hey, we accept your proposal, even by September 5th, they're not going to be able to get the permits and be mobilized to demo that.
Exactly. It's not a short-term project.
But I also don't want to kick the can down the road and then, you know.
No, neither do we. We'd like it done before he dies. He's that unhealthy.
If Mr. Donald here was able to secure the other buildings, not the one that's destroyed by fire, because it probably has like 300 different openings that people can enter through, and you know they communicate with you that you know they have a plan, and if that is moving forward the demo, they have you know the permit applied for and everything. Would the city, you know, be agreeable to that? Or is that something you think would resolve some of the more immediate concerns that the city has?
I would, and I think the stipulation on the permit is that the permit process be in its final leg or issued.
Not just
by
I
your
applied for it,
compliance
yeah,
date.
yeah.
Because again, once the demo permit's issued, yeah, there's 6 months for them to do that work and get the work done under the life of the permit.
Okay.
But, you know,
I don't
just
want to be
having a
here on
permit
September
under-
5th. Yeah, I don't want to hear it be on September 5th and they applied for the permit on September 4th. Right.
correct. And we've had that before where we've closed cases with the permit applied for and then I've come back in 6 months or a year later because the permit was never completed and approved. So, they have worked with me.
We want
It's
to make
just
your life
we-
easier, I promise.
We
I promise.
We just need something, you know.
In
again,
writing,
for
yeah,
them
Yeah, and I think, you know, having it more clear deadlines imposed in writing maybe will encourage your father-in-law
Definitely
to,
help, and push comes to shove, which my father is very much a person that craves control. He needs to be in control of everything. However, with the COPD and everything, it's starting to take its toll. He has full power of attorney over the trust.
right.
Push comes to shove, which will get extraordinarily ugly in our world, we can push to have him declared incompetent, but I don't want to have to go there if I don't have to.
Okay.
That would be the last ditch effort, but we really want to get this taken care of as much as you do.
And I'm comfortable if you want to set a different compliance date with,
Yeah, I'm trying to think. As far as, securing the structures from unauthorized entry, that's just a 301.3, right?
yes, sir.
All right, I'm inclined to keep that one at the strict deadline of September 5th. The other ones sort of all kind of fall together if they're demoing it completely, so.
Correct.
How soon do you guys anticipate making a decision on whether or not you have to demo demo all the
We got
buildings?
one more bid today, and I'm trying to stay on top of this. I've been on this 24/7 since
Is
he's asked
the-
me to help about.
Usually with
beginning of
these,
May.
when you have, a real estate transaction, any type of work that you do on the property while you're during the escrow period, you have to coordinate with the buyer. Is that something that the buyer is expecting you to do, or is it something?
I honestly have no idea, but I will be in touch with everybody because I want to make sure all the i's are dotted, the t's are crossed, and everything is done properly.
Because their due diligence periods allows them to investigate and make sure that the property is suitable for the purpose that they're going to buy it for.
Yes.
What is the purpose that they're buying it for?
It is supposedly a very large corporation that buys dilapidated, rundown places like the malls and like this gas station. And ultimately, they wanted to,
But they're not running a truck stop.
no,
Okay,
they
alright, so yeah,
ultimately
they-
wanted to put like a shopping plaza in there.
Okay, all right.
So it would all had to be demoed one way or another.
Right. So
it's
then
not
obviously
gonna
they'd want you to do
affect
it.
what they
Okay.
were gonna do. We assumed they were gonna demo it and
Okay.
and then all of a sudden, we just took a little circle.
All right. And 60 days just to get the permit applied for. I feel like that's reasonable because you do need time to consider the bids that you have. I don't want to bifurcate it so that something's at 90 days to come back in, but then we need to because, just having a permit applied doesn't really mean anything.
I know we're all stuck between a rock and a hard spot on this one.
Yeah. Well, the problem is you have power of attorney to speak on his behalf, but not to. So he's kind of hamstrung me in a way because I can't lecture you because you don't make that decision.
Yes, I understand. That the only way I was gonna get the power of attorney was to let him think that he was being
Okay.
kept in the
Yeah.
loop on everything, but
Yeah.
I'm also keeping him in the loop as if I'm talking to a 2-year-old.
Yeah. And this is my, and maybe Glenn, May, you can help me out, but if I say 90 days, the permit has to be approved, for them to do the demo work, but then they ultimately decide, hey, we can't do the demo work, we're going to sell it, and, the buyer doesn't want us to demo the work, now, where does that put us? There's just too many variables when you're talking about a buyer.
There are a lot of variables in that. We could give them the additional time to get the application permits for demolition to be submitted to the city.
Mhm.
And then therefore, we can monitor as they go forward. They can continue contact with us and with May as we move forward and see where we progress to. I think that by then would be ample time to either have sold it, demoed it, or
We'd also know where we stand with the EPA in 90 days as well, because they said that they expect the final reports sometime in early September.
but there again, that EPA report's not going to stop the demolition.
Oh, absolutely not. It would just affect,
Right.
you know, like
Your
some of the
decision-making,
cost of who takes up what parts of the concrete.
Correct, but in all reality, most of these would be resolved with the removal of the buildings.
But it-
100%.
If they were to submit an application no later than early September, how long would it take the permit application for demolition to be approved or
It
granted?
shouldn't take very long at all, I would imagine, within 2
So
weeks.
if they apply for it within 60 days and have it approved and not completed, but, you know, approved and issued
Right,
within
and
90 days?
They should be able to achieve that.
All right. Okay.
Thing.
All right.
I don't see anything that would hold that up.
All right, guys. All right, let me try to verbalize this. I'm very bad at this because I'm off script again. All right. But I'm trying to be fair.
I appreciate it because, you know, like I said, he's a very stubborn man, and I'm doing everything
Yeah.
I can to dig out of a very large hole.
Oh, yeah, I have in-laws too. All right, I have accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent George Raymond Donald Senior Trust is the owner with the address of 8251 Windover Way, Titusville, Florida 32780. I find that all required notices were provided in accordance with Chapter 163, Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of sections of IPMC sections 302.7, 304.1, 301.3, and 305.1 exist upon the property, and these are for accessory structures regarding the fuel pertains to all three buildings and their roofs and walls, vacant structure and land regarding securing the various buildings, and then the last one is just general interior maintenance. These all exist upon the property, and respondents were given a reasonable amount of time to correct the violations, but have either failed or refused to do so. The corrective actions for these violations are, as we discussed, you can remove all those structures or repair them, or and moreover secure all the structures from unauthorized entry. I do find that the city has incurred costs in the amount of $128.53. Such amounts shall be included with this order. Respondents shall be given until September 5th, 2025 to
September 5th or 25th? Earlier you said September 25th.
September 5th, 2025,
Okay.
sorry, to secure the structures and become compliant with 301.3. So you have 60 days to secure the structures from unauthorized entry to the extent they cannot be entered or used as a place of harborage. But I understand I don't know how to put it, but the fire damaged building, just do the best you can, you know. You're never going to fully secure that.
The buildings are already pretty much,
Mostly boarded up anyway, except for when somebody.
Well, then that's good. That'll be good. Then keep them that way. And then you'll also be given to that same date to submit an application for a permit to demolish the structures, not to get it issued, just to have it applied for, okay?
Okay,
You'll then be given until 90 days, so 30 days after that, to complete that application process and have it issued by the city, okay? Respondent shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation is September 5th, and then the date is 30 days after that, which I guess would be October 5th or 4th.
October the 10th.
10th would be the next, okay. Fine will be entered in the amount of $100 per day per violation until the violations come into compliance. And again, if the plans change with regard to demolition, with regard to the buyer, please keep Officer Wright apprised of
Oh,
any
absolutely,
developments.
absolutely.
Keep that line of communication open. So any further and future violations of the same section shall be classified as a repeat violation. Certified order may be recorded in the public records of Brevard County. It is so ordered. All right.
Quick question. Did you want a copy of this order sent to you as well as the?
That would be fabulous. I mean, in-laws have been pretty good about getting things to us, but they're starting to have selective memory
you-
and thoughts.
Can you give the secondary address on record, please?
Our home address is 6787 Acre Woods Court, 317.
Say that again. Sorry, I was looking at something.
6787 Acre Woods Court, 3 words, Cocoa, Florida, 32927.
Just to have a secondary copy sent out.
Okay. All right.
And we are going to, we plan to stay on top of this for my father-in-law and keep pushing him and
Right.
to get
All right.
it taken care of. We'll-
Thank you.
Thank you.
Thank you.
All right, and that takes us to our last matter, because it looks like one's removed. 25-120.
Three items to submit. The first is the notice of violation and affidavit. The second is the notice of hearing for today's hearing and affidavit. And the third is the cost recovery statement in the amount of $163.75.
Thank you.
So once again, this is the initial hearing for case number 25-120. Our respondent is Sarah and Rashis Investments LLC. Sammy Sayard, I have that in the wrong order, I apologize, is the registered agent for the LLC. The violation address is 5480 Wendy Lee Drive, Titusville, Florida. And our mailing address is 12707 Olton Circle, Orlando, Florida, 32832. So we have two violations right now. It's section 30-39, tree removal permit required, and section 30-83, prohibition, cleaning, storage materials, and equipment without permit. So the initial inspection was completed on March 14, 2025. The notice of violation was posted on March 21st, 2025. The notice to respondents was sent first class and certified on March 25th, 2025. The certified and first class letters for today's hearing was sent June 11, 2025. Copies were posted at City Hall and on the property where the violation exists on July 1st, 2025. So while I was driving in the area, I observed a lot along Wendy Lee Drive that had been cleared of tree stumps and site. We had installation of silt fencing around the perimeter of the property, and I took photos for the file. I reviewed the building department files and found no active permits at that time, though a previous owner had completed a site plan review for condominium development back in 2020 and 2021. Included in the reviewed documents was a copy of a tree survey confirming location of size of trees that had been on the lot, property appraiser's website. So I did speak with planning and building department staff concerning that previous development, that site approval. They confirmed that the site plan for the project had been approved, but the required pre-construction conference to obtain site permits was never scheduled. So a letter containing all this information was in the file, and that dated letter was March 21st, 2021. After getting all that, that's when I returned to the property and posted the notice of violation. So between March 28th, 2025 and April 2nd, 2025, I received phone calls. PI Homes, Fletcher Tree and Landscape, and Carver Tree Services, all with questions concerning my notice of violation, any previous approvals. I provided them with the same information I just provided you. The plan had, Then I talked to Sammy Sayard, the registered agent, on April 21st, 2025, concerning the violations at the property. He explained that it was their understanding that the approval of the site in 2021 gave the new owners permission to move forward with tree removal and site work. Again, we went over the history of that site plan approval, the March 2021 letter, and our next step in the case, that this is an irreversible, irreparable violation with the trees being removed without permit, and that we would be moving forward with scheduling a hearing. Due to some scheduling conflicts, we missed getting it on the May of Mr. Sammy during that April conversation. So these are the two code sections. Again, section 30-39 is specifically for the tree removals. And again, you cannot remove them without prior authorization. And then the 30-83, this is for the site work. Again, you're supposed to have approval for that site work and a permit issued prior to doing any grade. So this is a Eagle View map dated January 7th of 2024 from the Brevard County Property Appraiser website, showing it to be a fully wooded lot. Again, this is a copy of a from the tree survey from that project, listing all the trees that were on that site prior to the removal. This is my original photo from March 21st, 2025. We can see that all the trees and stumps have been removed from the property. So, conclusion of facts, both section 30-39 and 30-83, there were no permits in place at the time this work was took place. These violations are irreversible. We can't put that canopy back up. So at this point, we recommend that at the time of this meeting, the property be found in violation of code section 30-39 and 30-83. Order the respondents be assessed administrative costs in the amount of $163.75 and impose a fine of $5,000 per violation, as they are irreversible.
10,000 total.
Yes, or another amount of your choosing.
Is the respondent here?
So we have a representative of BPI Homes. He was contacted directly by the property owner. I don't know if do you want to hear from him?
Are you a licensed attorney or?
No. I was involved with the transaction when he bought it from the previous owner. I'm just friends with him. He had only asked me to come here to ask for it to be postponed, as he's still dealing with family matters. He's out of the country.
Yeah. Well,
I can't say how long he's asking for. I don't even know how long these hearings go. Are they once a month, every week?
yeah. Unfortunately, I can't really. You would be considered just the public, and there's no public comment portion of these hearings. I hate that you sat here through all of that for me to
Was
tell you that.
I mean, I've learned.
And as I understand it, this was rescheduled already at his request, correct?
Correct.
Well,
He did, he sent me an email last night and stated that he did ask for another extension or another postponement, but he never heard back, and that's the last
Right.
I had heard of it.
well, I appreciate it. You can, yeah, not much. I can't accept any more information
no,
from
I
you, so,
understand.
yeah, because you're not a witness or the representative of the owner, so I can't really take anything of that sort into consideration, so.
He did call in and requested an additional hearing because he has said he was going on vacation again. And I said that we had already postponed it once for you, and you set this date. If you want to send a notarized comment to us to read into the record, we'd be happy to do that, and we have not ever received anything from that.
When was the last time you talked to Mr. Sammy?
Based on my records, back in April.
But, okay, so, sorry. You said he picked this date, so you told him, hey, this is when the July date would be, and he said that should work for me?
So in the notice of violation, it stated we'd be moving forward with scheduling a hearing due to the irreversible, irreparable. And normally 30 days to respond,
Okay.
then we schedule it for May. So at the time of the April conversation, we had already missed sending out the notice of hearing for May.
Yeah.
So that's when I explained that we would be putting it on for the June 2025. He indicated that he was going to be out of the country and asked it to be postponed to the July. I got that approval from Glenn at that time, and that's why it was on today's.
Well, to any of the public that's here in attendance, if he were here, I'm not sure what evidence or anything he can provide to counter the fact that the trees are gone. So I'm not really sure what a 30-day or 60-day delay would really accomplish. So to that end, I'm going to go ahead and make my ruling because the trees are clearly gone. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondents Sarah and Khadija Investments, LLC, are the owner of the property of the address 5480 Wendy Lee Drive, Titusville, Florida 32780. I find that all required notices were provided in accordance with chapters 163 Florida statute and city code, and notice was met for this hearing. Based on the evidence presented, I find that violations of sections 30-39 and 30-83 were committed upon the property, and respondents were given reasonable notice of that violation. There are no corrective actions possible. Therefore, I will be imposing a fine of $5,000 per violation, as the violations are irreversible or irreparable. Additionally, I find that the city has incurred costs in the amount of $163.75. Such amounts shall be included with the order. Let's see. How long do they have to pay? 30 days?
Yes.
The respondents shall be given 30 days to pay the fine. They shall be responsible for notifying code enforcement of the of payment of same, and to confirm you don't have to confirm the status of violation. Further and future violations of the same section shall be classified as a repeat violation. A certified order may. Thank you. All right. I believe that takes us to the end of the agenda. We just have time for code enforcement manager's report. Do you have anything to report?
The only thing I have, sir, is we're still working towards the resolution to replace Ryan as the alternate.
Okay.
Once the new city attorney's on board, we'll bring that forward.
All right, sounds good. And then, no, we can talk more later. All right, perfect. All right, then I will adjourn this hearing at 3:49. All right, thank you.